Hello, and welcome everybody. Thanks for joining us again for another one of Weinberger Law Group's webinars. Today we're going to be talking about collaborative law, and we're going to give you an introduction to the New Jersey collaborative divorce process, how you can use collaborative law to keep your divorce out of court. First, our disclaimer. This presentation contains general information and does not constitute legal advice. Be sure to direct your specific questions about your own case to a family law attorney. What we're going to cover today, well, first we're going to tell you what is collaborative law. We're going to explain why you should use collaborative law for your divorce. How do you choose attorneys to represent you? Who are the members of the collaborative team? How does the collaborative divorce process work? And what happens if problems come up after your divorce is final? So let's define collaborative law. What exactly is collaborative law here in the Garden State? Well, it's an alternative to litigation. It's an alternative dispute resolution process. We call that ADR process here in New Jersey, and it's less conflict-oriented and less stressful than traditional regular court litigation. The goal of collaborative law is to find solutions that provide maximum benefit to each of you rather than having one spouse win and the other one lose. Collaborative attorneys work to help parties reach their own agreements and their own solutions without having to turn to the court or to a judge to decide their matters for them. Now, you may be wondering, how is collaborative law different from mediation? And without question, mediation is the most popular form of ADR here in New Jersey. Collaborative law is a newer and different type of ADR process than mediation. Now, both mediation and collaborative law approach conflict from a healing perspective rather than an adversarial perspective. Now, in mediation, parties work directly with a neutral third-party trained mediator who helps them negotiate their own solutions. Parties will then generally hire attorneys only as consultants, and attorneys rarely, if ever, attend mediation sessions. If parties fail to reach agreements during mediation, they can proceed on to litigation with the same attorneys that they used as consultants. Now, collaborative law is an even newer option. Couples who wish to avoid litigation altogether but feel they need a more legal support system can choose collaborative law. This process is suitable for resolution of all kinds of issues relating to divorce, including equitable distribution of property or debt, alimony, custody and parenting time, calculation of child support, really any issue that you may have in your divorce. Collaborative divorce can work. So how does collaborative law differ from mediation? Well, unlike mediation, there's no neutral third party overseeing the collaborative process. Attorneys and clients all meet together to negotiate solutions. Additional experts are retained jointly if needed, and they become members of the collaborative team. If parties fail to reach agreement through this process, they must start all over again with new attorneys before going on to court onto more traditional litigation. In fact, collaborative law stresses negotiation so strongly that all parties sign an agreement, a collaborative law participation agreement, where they promise in writing to pursue only an out-of-court settlement. The written agreement also includes promises to communicate honestly and completely and to negotiate in good faith towards a full resolution of all issues. The attorneys agree again to withdraw from the case if either spouse decides to file any court papers other than those necessary to complete the uncontested divorce at the end. So why use collaborative law for your divorce? What are some benefits? Some benefits are, first and foremost, the process reduces conflict. Litigation naturally tends to increase the stress that anybody feels during divorce by eroding openness and trust and encouraging spouses to fight for their own interests and against the interests of the other spouse. Collaborative law, on the other hand, encourages spouses to work together toward building mutually beneficial solutions. The format provides a safe and confidential setting, unlike an open court, which allows both spouses the opportunity to fully express what they need and what they want, which reduces frustration and fosters a more peaceful and constructive environment. The parties retain confidentiality, another benefit. Maintaining privacy can be really important in family law disputes where the details of a case can be really personal in nature. Couples who have the judge decide their divorce issues in court must have trials and motions in open court, where the proceedings become part of the public record. Another good benefit of collaborative divorce is the parties control the result. Attorneys and experts do not make the decisions for divorcing spouses the way a judge does. Negotiations help the spouses clarify issues, identify what's most important to them, and achieve mutually acceptable results. Decisions made in negotiations are not binding until each spouse signs a final marital settlement agreement. Because couples who negotiate their own agreements tend to be more satisfied with their results, they are often more likely to abide by the terms of their own agreement. Another benefit of collaborative divorce, the process tends to save everybody time. Litigation typically takes up to a year, sometimes even longer, and some complicated cases can drag on for really in what seems like an indefinite amount of time. But in collaborative law, parties can set their own pace rather than being at the mercy of the judge's calendars and the court calendars and deadlines. The time it takes to reach a settlement in the collaborative process varies, of course, depending on the factors in your case, the complexity of the issues, the number of the issues, but it's often a more rapid process than traditional litigation is. Another benefit of collaborative divorce, it may save you money. The openness of the process removes the need for time-consuming formal procedures. So if you agree to divulge all of your information, then there's probably not going to be the need for discovery procedures such as depositions, which take up more time and more money. Now, although there are two attorneys involved in the negotiations, the attorneys will not have to spend time preparing for or appearing in court. A huge benefit to the collaborative divorce process is the process protects children. It protects children emotionally because it reduces conflict between the parents and, it makes children feel pressure to choose sides. That won't happen here. It improves co-parenting. Keeping parenting disputes out of court helps parents preserve or improve upon the cooperative relationship that is essential to co-parenting. It builds communication skills. Parents who collaborate on parenting matters learn skills that can help them work through their future disagreements. And it reduces future conflicts. If serious parenting agreements continue to arise in the future, parents can return to attorney-supported negotiations to resolve issues out of court. Is collaborative divorce right for your case? How do you know if it is suited for your situation? Well, it's really suited for a wide variety of situations. It works for smaller cases because collaboration can facilitate a fair division of household contents without expensive court involvement. It's good for financially complicated cases because joint financial experts can work as part of your team in an open and effective manner. It's good for parenting disputes because, again, collaborative law can help you preserve your good relationship and explore amicable resolutions that addresses your children's best interests. And it also works for post-divorce issues. After your divorce is final, going back to negotiations can help you resolve post-divorce issues such as changes in financial support or changes in parenting arrangements. So are you good candidates for collaborative divorce? The only requirement is a willingness to work toward mutually beneficial solutions. The process is definitely easiest for spouses who are already amicable. Spouses who might have trouble with mediation due to difficulty communicating will benefit from the extra attorney support that the collaborative process provides. Spouses who still need additional emotional support can hire separate divorce coaches. So, how do you choose your collaborative divorce attorneys? What qualifications should you and your spouse look for? Well, at a minimum, find an attorney who has completed introductory training in collaborative law. Collaborative training provides attorneys with basic skills in creating effective and long-lasting solutions to common issues through this process. It also provides practitioners with interdisciplinary team training in which attorneys interact with mental health and financial professionals to learn how to provide the most appropriate support services for the parties and for the parties' children. When interviewing a prospective collaborative divorce attorney, what questions should you ask? Well, you should ask your prospective attorney questions about their background, training, experience with collaborative divorce, and other ADR processes such as mediation. You should ask your prospective attorney about the collaborative law participation agreement. Do they have one, a template you can look at? Ask them what kind of experts they think you will need on your collaborative team, if any. Ask what fees and what the fees include. Preparation of filing of the divorce papers. Is your attorney able and willing to do that? Ask about the estimated number and length of sessions for your type of situation. Ask about preparation of a marital settlement agreement, and also ask about how and when they will finalize your divorce. A frequently asked question is, can we both use the same collaborative law attorney? Many people choosing collaborative law think that since they're so amicable, it makes sense for them to try to save money by using the same attorney, but this really isn't possible. Regardless of how agreeable you are, you still have different and sometimes opposing legal rights and interests, and it's a conflict of interest for an attorney to represent two people with opposing interests in any area of law. So we're talking about this collaborative team. Who are the members of the collaborative team? What kind of experts will you need on your team? The collaborative team always includes the parties and their attorneys. That goes without saying. But the team may also include divorce coaches and any additional professionals necessary to properly evaluate your case. In most cases, the parties agree to hire joint experts and share the costs. Joint experts generally agree not to serve as witnesses if the case goes on to litigation, and any expert reports will not be admissible in court without the agreement of both parties. The following types of professionals commonly participate on collaborative divorce teams. Divorce coaches, what do? Well, a divorce coach is a mental health professional who helps each divorcing spouse manage the emotional issues that may come up during the process. The coach does not act as a therapist, but he or she does provide emotional support while also guiding parties in prioritizing issues and helps maintain good communication. Depending on how much individual support each spouse needs, divorcing couples can choose a joint coach or even individual coaches. A coach with adequate training in child development sometimes doubles as a child specialist. In other cases, there'll be a separate professional filling that role. What does a child specialist do? If there are custody issues to be worked out, the team will probably include a licensed mental health professional who has training in child development and family systems. The specialist provides information about children's needs and helps parents evaluate custody options. You want to choose someone with experience working with parenting issues common to family reorganization. How about some potential financial experts? These experts can also be part of the team. A financial specialist who ensures appropriate data collection and addresses tax consequences. Someone to evaluate or appraise your business or your property possibly a pension appraiser or an actuary, and maybe a vocational expert. This person would provide information about available jobs that fit the spouse's education and experience. How does the collaborative divorce process work? First, there's the initial attorney meeting. The parties and their attorneys meet for an initial conference to discuss important matters such as rights and obligations, confidentiality, use of joint experts and consultants, and how the divorce will be finalized. The parties then sign a collaborative law participation agreement. As soon as the participation agreement is in place, the parties and their attorneys discuss any urgent matters that might need to be addressed immediately, including financial support or custody or visitation arrangements. The parties and their attorneys then decide what other types of professionals to include on their team. The parties and their attorneys meet as many additional times as really necessary to resolve all of the issues in the divorce. Other members of the collaborative team participate as required. The parties exchange all information openly and efficiently, avoiding the need for any formal or court-regulated discovery procedures such as depositions or interrogatories. Once all issues are resolved, the attorneys put together a comprehensive marital settlement agreement, or MSA, to be filed with the court. So about that agreement, putting all of your issues and your agreements into writing is critical. The MSA is a formal legal document that you both sign and then file with the court. Your MSA will include all of the agreements you and your spouse have made, and it serves to resolve all of the issues in your divorce. MSAs were usually called property settlement agreements, but for couples with children, the MSA includes terms regarding child custody and support, as well as property distribution and other financial matters. Do you need a court hearing to finalize your divorce? Well, this depends on what county you're in. You will need to complete paperwork for a no-fault New Jersey divorce, and that needs to be filed with the court. If neither of you has filed a complaint prior to going through the collaborative process, your attorneys can file the complaint simultaneously with your MSA. In some counties, you still need to attend a really brief court hearing to finalize the divorce. In other counties, you can do the paperwork only, and the judge will finalize your divorce without a hearing. So what if you can't agree on everything? If you are unable to resolve all of your issues, you can still go to court. Under your collaborative agreement, each of you will need to get new attorneys to proceed and appear in court. What happens if problems come up after the divorce is over? What if things change and you need to make changes to your agreement? Child custody and child support orders can be modified until children are emancipated or deemed to be independent. Alimony is modifiable under certain conditions unless your MSA clearly states that it is not. All modifications require a substantial change in circumstances. Amending or enforcing your MSA. The majority of post-divorce issues occurs when one party fails to carry out the terms of the agreement. Your agreement can include an agreement that before either of you files a motion in court, you will both attempt to again resolve your issues amicably through mediation or perhaps another collaborative process. If you have any other questions about the collaborative divorce process, about mediation, about divorce in general, give us a call. You see our number there is 888-888-0919, or shoot us an email. We can be reached at info@weinbergerlawgroup.com. Of course, when you're ready, give us a call at our toll-free number. Set up a consultation with one of our knowledgeable and experienced family law attorneys. We have several attorneys on staff who are trained in the collaborative approach to divorce. We also have several trained family mediators on staff. So give us a call when you're ready to set up your consultation. We'd love to hear from you. And again, thank you so much for joining us. We hope you learned something on our webinar today, and we hope you join us again next time for another Weinberger Law Group webinar. Thank you so much.